At 8:30. Everybody ready at 8:30?
Yes, Judge.
Are you waiting for a court reporter?
No, Judge.
Okay, that's what I was waiting. I didn't know if you guys had a court reporter with us. Good morning. Very nice to see everyone this morning. We're here in Townsend versus Johnson, and we have set for hearing this morning. Plaintiff's second amended motion to expand discovery to include defendant's financial records. For the record, I had a chance to read the court file. I also read plaintiff's second amended motion, and I read the written response and opposition. You may proceed when you're ready, counsel.
Adam Sabosic, Your Honor, on behalf of the four plaintiffs, they're the decedent's four daughters. This action is an independent action on a claim that they filed regarding a breach of contract that we allege the decedent caused to occur regarding an old agreement, a 1983 agreement, Judge, in Oregon of all places, which I'm sure it's lovely there, but it's very difficult that the issues are complex.
Let me just get to the heart of the matter, because I read your motion and I read the response in terms of the access to financial records at this time with the other parties. That's what I'm concerned about, these particular accounts.
Okay, sure. So we've got this now this dispute over the scope of our discovery, whether or not we get to seek financial records from the wife, Mr. Downey's client, second wife. And Judge, what they're forgetting is they cite the Schlesinger case. The Schlesinger case is a wife that was also the personal representative of the estate, which our clients are not. And she filed a claim simply for breach of contract by the decedent. In this case, that's not the only claim we have. We have two counts in our complaint that are individually against his client. We have unjust enrichment and we have tortious interference. So we're stating that through her actions, she was able to wrestle away assets that otherwise would inure to the benefit of our clients, Judge. And they would like to say, look, it's enough for you guys to get the decedent's records. That's enough. You can prove your case by just getting
That's what was going to be my question. Why not start with those? Why? What else?
We did start with those, but we don't know the full extent of the transfers that she's received. And our discovery, it doesn't just ask for financial bank statements. It asks for records of all transfers that she received that are more than $5,000. We fought and fought and fought over the length of discovery that we would do. We got an order finally saying that we could go back to 1983 to get documents, but we started with the decedent's records, those financial institutions, and we have identified breaches of the agreement. Of course, our clients would point to those, but we can't prove all of the transfers.
Why don't you get the records from the other side, though? That's my question.
That's what we're asking for. That's exactly what we're asking.
No, but the records in the terms and the transfers out as opposed to the transfers in. Getting it from the other way.
The transfers out.
Yeah.
We've received those records.
Yeah, and what else do you know? What else? What is that not showing you that you need at this point?
That's not showing other things like jewelry, like other assets that were purchased for her potentially, and we don't know. We only got 7 years of bank records from the
only thing you need is specific documents. Well, we can talk about the time frame. That's separate. But if the only thing you need is documents relating to jewelry purchases, those types of things.
I don't know.
Perhaps we can narrowly tailor, because my thing is why invade someone's financial discovery when it's not appropriate, when we can do staged discovery and we can target exactly what you're looking for.
Yeah, we don't know what other transfers she received. It was a long-term marriage.
Okay.
We know that the assets depleted in 3 years from 20 million down to 5 million. So they went somewhere. We've identified some, but not all.
Okay.
And they say, look, we want to limit what the universe of
In terms of responsibilities.
Thank you, Judge. First, I apologize for getting that response to you so late.
Oh, I read it, not a problem.
Okay, well, thank you very much for that. First of all, Judge, just so you know the numbers, the numbers are grossly exaggerated and that they are not acknowledging the fact that there were large mortgages. So they throw this big number,
Okay.
and it's not even close to that.
Okay.
My client is the personal representative. She produced to them everything that the decedent had at the time of death in the name of his name and joint names.
Okay.
And she provided all sorts of documentation with regard to lifetime transfers that he made.
Okay.
Deeds, payment of mortgages, all of that has been provided. We did not object to their attempt to get all of the decedent's records. We've given them all the decedent's records. So you have honed in on the issue, which is in order to establish their case where they say he wasn't allowed to make transfers out.
Yes.
They've captured all of that. Now they know what we did with the money. And it's not relevant to their case. But by the way, apropos to their assertion of transfers out, they were the recipients, by the way, of a bunch of the money.
Okay.
So, in any event, case law, I think, is exactly on point. There's a case called Schlesinger, which said you can't look inside the transferees, what they're doing. And then I cited to you a Ford TCA case, which says, hey, maybe we're a native expertise. We're not there yet.
Okay, all right, thank you.
Reply, Judge Schlesinger, it's an accounting action. We don't have an accounting action. The case law is clear that if you're seeking an accounting, you need to show that you're entitled to the accounting before you start looking into the accounting transactions. That's not what we have here. We have 2 counts that are personally against his client. We want to know what she took away from our clients, one of who is disabled, by the way. And yeah, they received some funds from their father, but she got an infinitely more amount of money and property and assets from him than they did. And he's the one that agreed that they were going to get 50%, and then through this plan of the 2 of them throughout the years depleted his assets down to a mere fraction of what they were. He was a CEO of Pier 1. He had $20 million. Now the kids are lucky to see much of anything anymore. So, Judge, how do we prove our case if she doesn't have to open up and tell us what she received?
Okay.
And that's relevant to our 2 causes of action, and the case law says, sure, financial records are normally protected, but if they're relevant to your case, you get them. Schlesinger is inopposite here. Again, that's a PR asserting a claim. The PR already had access
What about
to
the
all
other Ford
records.
TCA case? Why can't you get the documents from the other side and do targeted discovery in terms of the transfers going the other way? That's my question.
The other side being
Yeah.
the wife,
Yeah.
again, wearing a different hat.
Yeah.
I want her records of what she received, because I don't know that I've received enough records from the decedent. We could only go back, they would only give us the last 7 years.
Okay. Well, we can
I don't know if
always
she's
look
got
at-
something before that.
Oh.
But we already have an order that says we get to go back to 1983 for all parties.
Okay, all right.
Not limited to just the decedent.
Okay, but based on the plaintiff's motion and the response in opposition, I'm going to deny the second amended motion to expand discovery at this point in time. What I need you to show me is that you haven't been able to get this information through the current means of financial discovery. You can always expand it. You can always seek to expand a current order if you need to, the time frame or the parameters, do interrogatories potentially, depositions potentially. There's other discovery before we're going to expand the discovery at this point in time. So the motion's denied without prejudice. All right, thank you guys. Have a great day, everyone. All right, let me please go ahead and do Regions Bank versus Litman, please. Counselor Lee? All right, good morning. Are we both sides here?
Actually, no, they're not. So
Okay, let's wait a few minutes, and that's no problem. All right, we have case management conferences. I'm going to go ahead and call them out so that way we can excuse everyone this morning. Valencia Falls versus Wolf. Anyone from Valencia Falls, Wolf? All right, good morning, counsel. Good morning. All right, good morning, guys. And what is the status of this case?
Well, I represent Valencia Falls, Your Honor, and it's our understanding that the defendant, if you will recall, he suffered a stroke and is allegedly disabled and not able to participate in the lawsuit, and that's our continued understanding. However, the concern we're having at this point is it has been at least 6 months since, that we were first made aware of this, and we would actually at this point like to have some information from the defendant to
Yeah,
kind of
what's,
substantiate that
do
position.
we have medical records, something?
Your Honor, excuse me, to finish, I'm sorry.
Yes, ma'am.
I'm Gary Glickman. I'm actually here for my partner who represents the defendant, Mr. Wolf, in this matter. Mr. Wolf is a retired osteopathic and physician and pharmacist.
Okay.
He suffered the stroke a year and a half
I know, but we can't really
But
state a case for...
he's refusing to go for medical attention. We provided an affidavit of his wife.
No, I need an affidavit of a medical provider. I'm sorry, because otherwise the case has to move forward. You can't just not,
Well,
you can't ignore everything.
And we attempted settlement
Okay,
negotiations.
well, that's great. Settlement's always great. So at this point in time, are the pleadings closed?
Yes, Your Honor.
Okay, I'm gonna set you guys to trial. When would you like to go to trial?
Your Honor, our client's incapable.
Then they need to settle. I mean, I don't have a choice.
In addition to physically unable, he's mentally deteriorated.
Then maybe he needs to get a guardian appointed potentially? I mean, I don't have a choice. If he's not capable of defending himself and he
He can't be
needs,
forced to leave his house.
then a judgment will be entered against him.
Well, we've actually offered a judgment on the issue of the injunction.
Okay.
The dispute is over, I believe, at this point, attorney's fees.
Yeah, then they'll get a judgment against attorney's fees. How much time do you need for the trial?
I
I would say it's going to take half a day.
Yeah, I think, you know, a day at the most.
That's like, we'll set you guys in non-jury jury.
I don't think anyone's requested a
Okay,
jury.
we'll set you for a non-jury trial in 1 day within 60 days. All right, thank you guys. Have a great day, Rob.
Thank you, Your Honor.
All right, then we do a Santa Lucia versus Macy's. Anyone here on Santa Lucia Macy's, council ready? All right, good morning.
Good morning.
All right. And what is the status of this case?
I don't know if we can get on the phone.
Sure, I need a phone number, please.
Yeah, give me 1 second. Okay, it's 484
484
60
60
44.
44. Got it.
Brian.
And they're not available. What's the
Okay.
status?
Yeah, so actually, when we last spoke in January, we did all the subpoenas from our deposition. As I mentioned in our previous status conference, I can't even speak today, sorry, status conference, there was 100 different surgeries that she had prior, so we did start receiving some of them, we just haven't received all of them.
Good.
We did do our second supplemental discovery.
Okay.
Right after our status conference, so we did just get those responses, and we have to now subpoena the additional
Okay. All right.
providers on there.
That's fine. We'll set another status conference, Michelle, 90 days. All right, thank you so much. Solutions in Construction versus Garda.
I was just gonna mention, I
Oh, sure.
am scheduled to give birth in the beginning of July, so I'm not sure if it'll be.
Hey, we'll do it, you want to do that for maybe August, September? When will you do that?
September.
September.
Okay,
September.
thank you.
Okay. All right, Solutions in Construction versus Garda. All right, council, good morning. What's the status of this case?
Yes, good morning, Your Honor. And the Finance Council was here, but we talked, we're on the same page. He said he asked me to go forward, she had a hearing next door. So we've started formal discovery. You can probably see from the docket, you've been lenient. We've been working together a long period of trying to conciliation, and but basically, we're asking for another 90-day CNC.
Okay.
As I said, we served discovery, we're moving forward, depending on what we get, if we get anything, we may have motion practice, we may have to amend our answer.
Okay.
We know you're going to require mediation.
We are.
So rather than set something for the end of the year, if we come back in 90 days, we'll know
Okay.
whether we've got it.
I think that's fair. 90-day CMC. That's fine.
Thank you.
Thank you so much, council. All right, TD Auto Finance versus Ruggiero.
Morning, Your Honor.
Good morning. What's the status of that one, Ms. Parsons?
I was here in January. You asked us to serve the defendant. We had an alias summons issued. The process server went out on 4 days after the status conference to the PO box, and they will not confirm or deny, and they refuse to say whether the person has a box there. So at this point, we remain non-served, but we think that she has a PO
Okay,
box.
I'm going to dismiss the case if you guys can't get service then. Okay, case is dismissed.
Thank you.
All right, thank you. All right, LHE Ventures versus Agilent. Anyone hear that one? No? Brook versus Procorp Debt Solutions. That's ready now? Good morning. All right. All right, good morning, gentlemen. What is the status of this case?
Well, Your Honor, this case has actually been consolidated with another case. Our case is at issue. We can probably set a trial date a couple months down the road, but the other case is not at issue.
Yeah. So, what do you want? Do you want me to wait, or what would be better?
Well, we would like one trial on both cases because the parties are suing on the same settlement agreement.
Okay.
The problem is in the other case, the Garborough versus, where Mr. Garborough is the plaintiff, the problem in that case is that the defendant Procorp and David Mahler, when we were conferring,
Yeah.
hasn't been served with process. So that is holding up,
Okay.
setting that case at issue.
I actually think they've been served. I think they just haven't been defaulted.
Oh, so
So
that's the status. Okay.
we're
So
pretty
would you,
close.
if you guys want to, I can give you another status conference, and hopefully you'll get service in the other case. And would that be better, or do you want a trial date in this case? Whatever you prefer is fine.
Probably another CMC because I know my client is up in New York a lot
Okay.
right now because his mother's
So maybe
sick.
120 days then, and maybe that'll be enough time to get service and get the plea, or at least get the default then?
Well, Your Honor, I think that the part of the problem is on the service list for today, Kevin Garborough, who's the plaintiff,
Yeah.
also who's the attorney in the case, he was noticed on the service list. It's his case where he's not pushing that case forward. He's the
Oh.
plaintiff, and he's not here today. So we can show up again in another 2 months or 4 months,
He's
but
not.
we may have exactly the same
Okay,
issue.
do you have the case number for the other case?
I do, Your Honor.
Let me do that, because we can,
Yeah.
what we'll do is we'll set them all at the same time, and we'll order him to appear. If he doesn't appear, then that'll take care of the issue then.
Perfect, yes,
Okay.
thank you.
So what's the case number in the other case?
It is 502017,
Okay,
000403.
wonderful, thank you. So what we'll do is we'll do a case management in both cases simultaneously, so that way we have all the parties here, and then way we can figure out exactly how to resolve that case and consolidate that case with this case and move it forward.
Perfect.
All right, thank you guys.
Do you
Have a
want us
good
to
day.
write up the order for
Yeah,
that?
just do the order then, that would be excellent, and
Okay.
then we'll do a 90-day case management, but that'll be enough time to get everything all set squared away then.
Okay. All right,
Perfect, thank you guys so much.
Thank you.
All right, let me go ahead and do Cheney versus Wilson. All right, good morning, guys. Nice to see y'all. All right. Good morning. And how are you guys doing? What is the status of this case,
Your
guys?
Honor, we've got counsel.
Oh, sure, give me your phone
for
number.
defendants on the phone.
Yeah, I just need a phone number. Thank you so much. Oh, no problem, let me give you a call.
Good morning, Berkeley Law Group.
Oh, good morning, this is Judge Sasser. I'm calling on the status conference, Cheney versus Wilson. Are you ready to proceed? I need Jennifer.
Yes, Your Honor, let me transfer you to Jennifer Seibel. She's the attorney
Wonderful.
on the case.
Thank you so much.
Good morning, this is Jennifer.
Good morning, this is Judge Sasser. I'm calling on the status on Cheney versus Wilson, and I'll start with the plaintiff's counsel. What's the status of the case?
Your Honor, as you may recall, you just entered an order that a lot's happened since we were last
I know.
before you.
I know, it's good.
And no fault of either side. There's been some delays. I will tell you, my client had her first child, and
Okay.
that has slowed things down because she didn't want to be in trial with a newborn child. You had promised to specially set us. We have discovery to do. You've entered the order that was the product of our hearing before you, the last
Yeah.
time we were before you. I think we're looking at fall next year.
Is that something, let me know when you guys are ready. Again, I'll set you guys whenever you're ready. I'm happy to hear your motions, whatever you guys need. So just let you know we're here for you guys, and let us know when you're ready, and we'll set you guys to trial.
We will get that. Thank you.
Okay, thank you guys.
Thank
Have a
you.
great day, everyone. Thank y'all. All right, let's do Lopez versus Tropical Financial, please. That's ready? All right, good morning, everyone. This is Lopez versus Tropical Financial. And good morning. What is the status of this case?
Good morning, Your Honor. Jason Cornell for the plaintiff. So, Your Honor, 6 days ago, Your Honor entered an order denying class
That's right.
certification. And so what we would do, I'm not sure.
Here.
Who has it?
Oh, here comes counsel. Yeah, you guys got the class cert order? Okay, good.
Yes, Your
So
Honor,
where are
sorry.
we now at this time?
So we would ask, Your Honor, that the court continue this for 30 days. Respectfully, we're considering taking it up on appeal. And
That's
so
fine, that's no problem then. Okay, 30 days it is then, that's no problem then. We'll do another status conference. All right, that's fine, 30 status conference, 90 days then. Thank you guys, have a great day.
Thank you, Your Honor.
Thank you. Plumber versus TW Food Distributors.
Good morning, Your Honor. I'm here for plaintiff.
Yeah.
Esther Zerlitsky.
All right, good morning. And what is the status of this case?
I set their motion to dismiss my amended
Oh,
complaint.
thanks, counsel, okay.
Judge Melissa makes
Yes.
out on behalf of the defendant.
Yes. Okay.
And I set it for hearing,
That's
but they
fine.
canceled it because the plaintiff is deceased.
Oh.
So I did a motion to substitute the estate,
Okay.
but we opened up the estate, the court took the petition for administration, but we had a problem with the filing fee, that
Okay.
the parties are indigent. So, but the rule says all you have to do is file the motion to substitute the estate, and it didn't say that you cancel all the hearings,
Okay.
but they canceled the hearing.
Okay.
Judge Lee, I reviewed the case law. When there is a notice of death of one of the parties, the case is automatically abated until the amendment is procedurally accomplished. My review of the case law is that the estate has to be opened, and also that they must be the new named plaintiff. So procedurally speaking, our motion to dismiss was one abated and two not equilibrated at that time. So I think we just need procedurally.
So can I give you another status conference maybe in 60 days then, and in the meantime? we'll get
Yeah, I
that
have to,
taken
the
care of?
parties don't have any money to pay the filing fee. We did the indigency affidavit. Usually, the court takes
That should
it.
be no problem at all.
No, the court said now, it doesn't matter if the estate has no assets. The petitioner who's filing to open the estate has to be indigent.
Okay, well, let's maybe try again. I don't understand.
I'm gonna
don't
try. I
understand
didn't-
that.
I never saw
So,
that
Yeah,
one
that's kind of an
before.
odd one. So let me go
Okay.
ahead and do another status conference. We'll do 90 days, and then hopefully in the meantime, you can get that opened up, and then you can just hand the order to the bailiff then.
Just say 90
90 days
days.
status conference.
Thank you.
Okay, thank you guys. Have a great day. All right, Schwartz versus ESS Investments. That's right. All right, good morning. All right, good morning, guys. What's the status of this case?
Good morning, Judge. We're asking to be set on the June docket. We're presently actually under April. I had switched firms and all the deadlines kind of...
No problem. Is that, well, as long as both sides agree, it's fine.
As long as it's either the end of June, beginning of July, it's fine.
I'm gonna special set you guys anyway. When you get closer, let me know what week works. You'll get whatever week at once.
Awesome.
So Michelle, they're off in April. We're sending you a trial over for June. Okay,
Thanks
have
so
a great
much.
day.
Bye, guys.
All right, thank you. Condor West versus Rhino Supply. Anyone here on Condor West versus Rhino Supply? No show? Paybon versus Security Protection. Sounds great? All right, good morning. All right, good morning, guys. What's the status of this case?
Good morning, Your Honor. We're set for mediation on April 2nd.
Excellent. Good.
So,
Hopefully you guys can get the
hopefully it gets
case resolved then and go forward then. Okay,
Pushing
that's
forward.
fine. Well, we'll just leave it as is, Michelle, and we'll do a 90-day status conference in case it doesn't settle.
Did you want me to?
Yeah, just put that in the order.
Will do.
Perfect, thank you so
Thank you,
much.
Judge. Thank you.
Dana Star versus Chapman. Anyone hear that one? No? Garcia versus Morgan.
Over here, Your Honor.
Oh, you're Dana Star. You guys Dana Star?
Yeah, we're just
Okay.
a little slow. This one Connolly representing Progressive,
All right.
and we have someone, the plaintiff is on the phone.
Sure, what's the phone number?
This phone number, sorry.
I want you to look that up, Your Honor. Her lives on behalf of R.D. Chapman.
734
734
347
347
0765.
0765. Okay, got it. Oh, good morning. This is Judge Sasser. I'm calling you on Dana Star versus Chapman. Are you ready for the hearing?
I am ready, thank you.
Wonderful. Counsel's here in the courtroom. What's the status of the case?
The status of the case, Your Honor, is we went ahead and amended to add a party defendant. We did perfect service upon him, however, there is a pending motion to strike affirmative defense on the part of the third party tortfeasor.
Okay, that's fine.
We're looking to get that special set on a 15-minute motion calendar, and then we'd be at issue and ready to be sent on trial docket.
That sounds perfect. So what I'll do on that one, I'll give you guys a 90-day status conference. You should be able to set your special set hearing in the interim and then get the pleadings closed, and then we'll give you guys a trial date.
Thank you, and thank you again for allowing me to appear to the line.
Oh, not a problem then. Okay, thank you guys.
Thank you.
Have a
Thank
great
you,
day.
Honor.
Thank y'all. All right, let's do Garcia versus Morgenstern. Somebody in that one? All right, good morning, guys. And what's the status of this case?
No, no, this, Jason McIntosh on behalf of Paula Garcia. I just entered a change of attorney a couple of weeks ago. The original attorney left our firm. And we have some outstanding discovery that we owe the UN carrier in the case. We dismissed Mr. Morgenstern.
Oh, okay.
We entered a notice of voluntary dismissal. I think it was signed in November of last year. So it's just Ms. Garcia versus the UN carrier in this case.
Are you guys at issue? Pleadings closed?
We are here, the issue here is that the UN carrier wasn't added till July of 2018, so it's sort of a new case on July of 2018.
Got it. That's fine. So let me give you guys more time. You think maybe a 90-day status conference would be helpful then?
Yes, sir.
Okay, 90-day status conference it is then. Let's get your pleadings closed, and then we'll get you guys a trial date then. All right, thank you guys. Have a great day.
You too.
All right, Scott versus Seal. All right, that's ready? All right, good morning, gentlemen. What is the status of this case?
Your Honor, we are plowing through discovery. Medical records as quickly as I can. I've got to do a CME. We should be ready in 6 months.
When do you think? 6 months from trial, probably?
Yeah, I'd like to have 6 months trial
That's fine. That's no problem. If you guys want to, I can go ahead and give you September. Is that okay? September date?
August?
August? August good?
Rather do September, but.
Okay, we negotiate. We'll set, that's fine. We'll set you, send you an August trial date. I'll order today then.
All right.
All right, thank you guys. Have a great day.
Thank you.
We just did Scott versus Seal. Okay. Alietta versus Chafanti Condo?
That's true.
All right. All right, good morning, counsel. And what is the status of this case?
Your Honor, the parties are in the process of setting depositions. We just gave a date that our client is available to plaintiff for deposition in March. I've asked for one of the defendant Transfield's corporate representative deposition. It took some time, Your Honor, for the proper parties to get into the case, FDOT and Transfield, and they played some musical chairs with their counsel, but I think everyone is in the case now, and we're moving along.
Wonderful. So you guys want a 90-day status conference? Would that be helpful? Yes.
Yes, sure.
9 days. 90 days it is. All right. Thank you guys. Have a great day.
Thank you.
All right. Let me go ahead and do Fernandez versus Interstate Cleaning. Council ready now? All right. All right. Good morning, council. And what's the status of this case?
Well, I have a plaintiff counsel is by telephone.
Sure. Yeah. What's the phone number?
It's 954-734.
734.
2382.
Okay. Got it.
Kelly Roden.
Okay. Let me give him a call.
Thank you for calling Leader Law. This is Sam. How can I help
You
you?
said it's Miss Rhoda?
Roden.
Miss Rhoda. Is Miss Rhoda available? This is Judge Sasser. I'm calling you on Fernandez versus Interstate Cleaning.
I'm sorry, who am I speaking with?
Judge Sasser. I'm trying to reach Attorney Roden.
No problem. Give me one moment.
Thank you.
You're welcome. Good morning, Your Honor.
Oh, good morning, counsel. This is Judge Sasser. I'm calling in Fernandez versus Interstate. What's the status of the case?
So we're still trying to get started on one of the defendants. We filed a motion to dismiss the time a couple months ago. Certainly we reordered it and they had a couple questions about it and haven't gotten back to him on his questions.
Okay. That's fine. Any objection to extending time for service?
Well, actually, I'd rather talk to her and deal with that. I don't know yet my response on that.
That's fine. That's fine. If not, go ahead and set it for hearing. Then I'm happy to go ahead and consider the motion for extension of time then. So set that motion for extension of time for hearing, and then we can consider providing additional time for service. What I'll do is I'll do a 90-day status conference. Hopefully you'll get just get service in the interim then.
Okay.
All right. Thank you guys. Have a great day, everyone. Thank you guys. All right. Wells versus Amerigo Recycling.
Morning, Your Honor.
Good morning, gentlemen. All right. And what is the status of this case, guys?
Your Honor, we have a motion for summary judgment to set on April 18th about setting 3 depositions of the employer in this particular matter.
Great.
And hopefully, just FYI for the court, I'm on the son with some terminal health problems. Term to work, so there might be another attorney.
I'm so sorry. Okay, that's not a problem then. So do you want to go ahead and you can proceed with the summary judgment? If you want to, you can cancel. I'm happy to work around your schedule, whatever is best for you.
I'd like to see if the case can be resolved based on these depositions.
That's fine then. So what I'll do is I'll do a 120-day status conference, and if someone else needs to get in the case, that's perfectly fine then. All right, thank you guys. Have a good day, everyone. All right. Let's please do Rutz versus Allstate. All right, morning, counsel. All right, counsel, good morning. What's the status of this case?
Good morning, Stephen Sorensen on behalf of Allstate. I've recently taken over this case from a prior attorney, and the depositions of the plaintiffs need to be reset because the prior attorney was in trial, and then we need to set a CME afterwards. So I would ask for another case management conference or status check in 90 to 120 days.
Is that okay?
Yeah.
Or we'll do 90 days. That's fine, 90-day status conference then. All right, thank you guys. Have a great day.
Thank you.
All right, let me go ahead and do CD Holdings versus Baker, please. Counsel, ready on that one? All right, good morning. All right, good morning. What is the status of this case?
Your Honor, we have an agreed order transferring this case to Judge Nutt for 2 reasons. There's a related case with a lower case number, and Mr. Sestero and I represent the defendant in the divorce case as well.
Not a problem then. Just hand that order up. I'll be happy to sign it.
Yes, and if I may, Your Honor, there's another case that's a related case to this case in front of you, and we have an agreed order transferring that one to Judge Nutt as well, so they can all be consolidated.
One, that makes sense. We'll take care of all the orders for you. Thank you guys. Have a great day.
Thank you.
All right, let's go ahead and do, please, Seacoast versus Houston. Seacoast versus Houston. Good morning.
There's summary judgment prepared this week for the ad tape.
Wonderful, that's fine. You want to set that for hearing maybe within 60 days then?
I will. You want to propose because the defendant can't do the defendant online, so
Yeah, I'll take care of
for
that.
you.
Yeah, that's no problem. I will take care of that.
Yeah.
All right, good seeing you. Have a
Good
great
to see
day.
you. Take care.
All right, thank you so much. Let me go ahead and do Subway Real Estate versus Georgie.
Good morning.
Good morning. All right, and what's the status of this case?
Seth Bennis on behalf of the plaintiff judge. After filing this action, plaintiff was going through an internal reorganization, asking us to hold off. They've since told me to proceed. We've propounded discovery. The defendant filed an answer. Pleadings are closed. And so we're just waiting for discovery.
That's fine then. Do you want to trial date or do you want to wait?
I'd like to wait at this time and see.
That's fine. We'll do a 90-day CMC on that.
Sounds good. Thank you.
All right, thank you so much. Anybody else here for case management? Otherwise, I have UMCs. Which case are you here on? Come on up.
Christiana Trust versus Robert Thierry.
Oh, yes. All right. And what is the status of that case?
Good morning, Your Honor.
Good morning.
Your Honor, Sabrina Novosky for the plaintiff. So in this case, we currently have a subpoena outstanding. It's our last thing that we have to do. The case is at issue.
Right.
We came last time, and I believe you said they wanted to set up for trial, but a trial order has not yet been
It should
issued.
be. We'll get a trial order for you. Give me the case number and we'll send. When would you like to go to trial?
Maybe like August?
That's fine. That's not a problem. Then we'll send a trial order for August then.
I filed some discovery this morning, the interrogatories, and a subpoena, and I have a few more things going on over the next 2
Is
weeks.
August okay for trial?
August.
August. Okay, August is. We'll send a trial order today for August. Thank you guys so much.
Thank you.
Let me go back to UMCs. Courts of Point Beach versus CDI Florida. All right, good morning. We have a couple motions. We have a motion to strike, a motion for extension time, and a motion for leave to amend. And of course, I'm going to grant the motion for leave to amend. And the motion for extension time, is that moot at this time?
Well, Your Honor, it's not moot, it's still the same party. The reason that we did a motion to strike is that the defendant is actually it's the registered agent who's moving for a motion for extension of time. It's not actually the party. The party is dead. The corporation is CDI Florida.
Okay.
It's single member LLC, so we need to now add all the heirs because they have an interest in it.
That makes sense then.
So
Okay.
I want to strike
There
CDI,
says motion for extension. then.
motion for extension, and then I'm going to move the default CDI.
Okay, that makes sense. I'm going to grant both motions and just hand the
Thank you,
orders
Your
to
Honor.
Bailey. Thank you so much. Let me go ahead and do Regents Bank versus Lipman. Council Reagan? All right.
Your Honor, this was defendant's motion to continue trial.
Okay, and they're not here, and that's going to be denied.
Okay, and our cross motion to special set MSJ before the trial.
Yeah, that's fine. You can set that at UMC anytime you want to.
Okay, the trial was set for March 21st.
Oh, that's fine. Oh, so actually, you know what? So we need to do the UMC before then. So trial is set for March 21st. Just contact Michelle. She'll work it out then.
Terrific.
All right, thank you so much. All right.
So no action today?
No action today. Michelle will work it out for you.
Thank you so much.
All right, let me
Good
go
to see
ahead
you
and do,
again, Your Honor.
yeah, let's do Beirut versus Universal Property and Casualty. Councilor Reagan?
Good morning, Your Honor.
Good morning. All right. Okay, and this is your motion to enforce the settlement agreement. And I had a chance to read the motion. You may proceed when you're ready.
Thank you, Your Honor. Andy McDonald on behalf of plaintiffs, Mr. and Mrs. Beirut. Real quickly, if I can show you the email which settled the case between myself and Mr.
Let
Watson.
me just ask you, is this going to be an evidentiary hearing? Do we have to have an test for it? I didn't know that.
It's just whether or not a release was a condition
Okay,
of
got it.
payment,
Okay.
Your Honor. So Mr. Watson emailed and said, hey, before the deposition, can we settle this? I gave him a number. He came back, tried to get a lower number. I said, no, he accepted the higher number. And that was it. The condition of settlement was never, a release was never a condition of payment, Your Honor. 627.4265 says that you can settle with your insurance company because it's a homeowner's claim against their own insurance company. You can settle with them and checks are due within 20 days. Or if it's conditioned upon a release, then it's due 20 days from when the release is provided. So I responded to Mr. Watson. I said, hey, it was not a condition of settlement. However, if you would like a release, please send it to me. Just make sure it's not a condition. 14 days later, I was bugging him every other day. My clients were like, where's the relief? Where's the money? Where's the... 14 days later, he finally gave me the release, and the release said, the checks are not due for 20 days. It's a condition of payment. So we just want an order saying that a release was not a condition. We're happy to provide them a release, but that the checks are overdue and that interest pursuant to the statute is owed.
Let me hear a response.
Yes, Your Honor. Lee Watson on behalf of Universal. Your Honor, I have an email as well where he states that the release is not discussed as a condition of settlement. If I may approach, Your Honor?
Sure, let me take a look.
And I've also got a copy of the proposed language behind these.
Oh, here's my problem. If we have this, then we have a factual dispute potentially. That's my issue.
And Your Honor, the burden is on the moving party to show that there's mutual assent here. The problem I'm having with the email that he sent is that he states in the email, I have no problem with it being a condition. I have no problem with the release as long as it mirrors a release that we did in another case. And the release in the other case had as a precondition of the settlement check a signing of an executed release. So we've got to receive the release before we issue the check. it mirrors the language that said, it did exactly what he wanted me to do in his email.
Okay, so how do we fix this?
Right, we're in agreement that the case is settled, it's just whether or not the checks are overdue as we sit here today.
Can we put the check in someone's trust account pending that? Is that possible?
Well, we need a release. That's all we need a release. He doesn't want to sign a release that says
That is-
the release is a condition of the settlement.
Can we do it by a court order? Is that possible?
Yeah, that's what we're asking for, is that the checks are due, that...
But instead of making him sign that release, then just by doing it by court order, then can I do it that way? Is that a way to help you guys out?
Yeah, 'cause I think that would help
Judge,
them so that they
well,
can...
if the order says, if the order says that they need to execute a release, absolutely,
Would
because
that help? I mean, I think that'll help, right?
Well, if the order says that it's not conditioned upon the payment...
It shouldn't be conditional on payment, but then you execute the
he
release.
said that though, in his email.
Okay.
He says, I have no problem, as long as it
does say,
mirrors the language.
You're correct, it does say that.
And if you look at that release, the language in paragraph 5 does say that you have to execute the release before we issue the checks.
And I've told him from the beginning, I have no problem providing him a release, but the condition of payment was never a term of settlement for this particular case.
Well, but that's the language here, that's the issue.
Exactly.
So, what I'll do is let's put the money in the trust account, and I can do it by court order if that works, then. And just order them to go ahead and put that language in the release then, if that works. Is that okay? We gotta protect it?
So when's the full amount's due to the trust account, how...
10 days?
Within 20 days. Within 20 days, as long as they execute the release, we have no problem issuing the check.
That'll protect your client.
This is the whole problem, is it took them 14 days to even get us the release.
Oh.
And so 20 days, it was 10, Your Honor, and then now he says
Whatever you
20.
guys can negotiate it, 10, 20.
I just want to we want to get the check, so we can get 10 days from today.
Let's do 10.
From today?
10 days.
No, not from today, but we need it from the execution.
10 days from the execution of the release, then, let's do it that way. But let's do the order, the execution release by court order then. So that'll be a requirement then.
So they're going to have to change the release, so it's due 10 days.
Yeah.
From when we give them the release.
I think that'll solve both sides' problems.
10 days from...
And that'll protect you guys because then you'll have a court order.
Exactly. As long as we have a release, I'm sure we can get it done within 10 days of the execution.
That's fine, so the release has to be changed 10 days from when the release, that's fine.
Yeah, that'll protect you guys.
I have
Just put it in
draft
the order
orders.
or just email, whatever's easier.
I have draft orders, we can sit down and hammer that out.
Thank you guys, have a great day, everyone.
Thank you.
All right, let me go ahead and please do Texas Capital Bank versus Nelson. Anyone hearing that one? No? Okay. All righty. Talion versus Lux Design?
Good morning, Your Honor.
Good morning. Good
morning, Your Honor.
Good morning. Okay. All right, and this is a motion to compel sanctions and for contempt of court for failure to comply with the court order and overruling the objections. All right, where are you guys at this point in time?
Your Honor, we on Monday evening got 13 pages of documents,
Okay.
which is woefully insufficient. There's 25 vendors in this case.
Okay.
We've asked for all the payments made to the vendors, all the checks, all the canceled checks, all the bank statements. We got literally nothing in response, and we've given them an extension of time.
Are there any
to
of the
respond.
documents?
No, Your Honor. We just recently substituted in as counsel in late February, around the 18th of February, and we've gotten documents from former counsel and from the client, and the production that we provided to them, bank stamped, is everything that
So
we've
they're saying
got.
there's nothing else out
Well,
there?
here's the problem, Your Honor. When we were here before the court back on June 24th, we said, we want these subpoenas issued to the vendors so that we can get the documents.
Sure.
And you said, well, right now, I'll sustain their objections pending what they produce to you.
That's right.
Now we've got virtually nothing from them. They're saying now that they have nothing. So if
So
they
we
have
need to go
nothing,
back
I
and
need to go
revisit
back
the
to the
objections.
vendors.
We
I
need to
need
go
the
back to
subpoenas issued.
Then you should be able to get subpoenas sent. That you're exactly right.
Exactly.
Yeah, because if you have nothing, they have to have a chance to be able to verify that. So at that point in time, I think there's a legitimate basis for them to go send these subpoenas out. So would you still maintain the objections on the subpoenas?
We do maintain the objections, and maybe we'd like to set it for.
Why don't you guys set that for UMC? Because I think you're right. I think you're exactly right. You should be able to start the subpoenas now.
Judge,
If they don't
we
have
asked in our motion today
Yeah.
to have those overruled because
Okay,
I
that's
don't
fine. At
think
this point in time, I'm going to overrule those objections because I think they're entitled to them. They don't have a basis to get them. So the objections are going to be overruled.
and the court will issue the subpoenas.
Well, I don't know if
And
it's subpoenas, but
I'm not sure how many of the vendors they're trying to subpoena.
How many vendors are there for this case?
I don't recall, but it's not every single vendor, but it's the ones that are relevant.
Okay, that's fine. Then why don't you do this? Why don't you send them a list of the subpoenas that you're going to be sending out? But at this point in time, I'm going to overrule the objections. If you have anything else, you can always file a motion for reconsideration.
Okay.
So, but any objections are overruled.
Judge, we asked for costs for this hearing only because we had to come back to the court again. They haven't produced the documents.
Okay, let me do this. Let me reserve. I'm not going to deny your costs. I'm going to reserve on them because I want to see that, because you're entitled to all the documents.
Yes.
Absolutely. If you don't get the documents, then I will enter sanctions then.
Okay, thank you.
All right, thank you guys. Have a
All right,
great day.
thank you.
All right, Deutsche Bank versus Toscana. Anyone hear that one? No? Okay.
Is that,
Deutsche Bank Toscana. It's motion to compel mediation?
oh, no.
Nope, not yours, okay. And then I have Deutsche Bank Kaufman.
I am here on that.
Okay, that is a motion for file verified complaint and additional cause of action. Okay, that's fine. I'm going to grant that for you.
I've got a proposed order here.
Okay, that was fine. That should be all. I also have U.S. Bank Waller.
Yes, Your Honor. Mr. Pachansky's here for that one, off of the defendant's, their motion,
Okay.
which we...
Are you closing?
Yes, Your Honor.
Okay, so are they here?
He's here, he's in, I believe, in
All right, no problem.
Tennessee.
Ward Damon versus Varga. Motion for order to show cause. All right, good morning.
Good morning, Judge Sasser.
Yes, a motion for order to show cause and petition for continuing writ, which I read, Mr. Lowy, and you may proceed with your writ.
Yes, we were here before the court back on January 22nd.
Yeah.
The court granted our motion to compel the production of the fact information sheet. It's been disregarded again.
But at this point in time, you're certainly entitled to the sanctions. And so I'm going to go ahead and do the show cause. We'll set that for UMC, and then I'm going to grant the petition for continuing writ as well, so that way you can continue getting the fees and costs and
Thank you.
tax on it. So just pick a date and time that works for you. Any date that works for you for UMC is fine for the show cause. But you have to make sure you serve them with the order.
That's
a
a challenge as well.
I know, that's always, I know, but that way we make sure they have notice for the show cause.
Do I need to give you the order here?
Yeah, we give the order and then I'll sign it.
And also for the writ of...
Yeah, I'll do both.
Thank you, Your Honor.
Thank you so much.
Have a nice day.
All right, Bank of New York Mellon versus unknown spouse, is that yours?
That's me.
Okay, let me do that one. All right, that's a motion to reset. And
Correct.
when would you like your foreclosure, sir?
35 days, please.
Okay, 35 days it is.
Thank you.
All right, thank you so much. Now let's do U.S. Bank of Waller. Both of you?
Still waiting for Mr. Pachansky.
Okay, all right.
I can try to go next door and go get
No
him.
problem then. The 9, anybody else here for UMC? Otherwise, the 9:30. What case you here?
I'm here on Texas Capital Bank versus
Oh,
Jeffrey
yeah.
Nelson.
Yeah, okay, I do have the motion then. All right,
I'm
so.
sorry, Your
Oh,
Honor.
no problem. All right, let's proceed.
Your Honor, this is our motion to substitute party plaintiff during the pendency of the case. Loan has been transferred from Texas Capital Bank to Nation Star Mortgage LLC, doing business as Mr. Cooper.
Okay, not a problem. I'm happy to grant this up then. So just hand the order. Not a problem then. All right.
Thank you, Judge.
Mr. Pachansky, let me do your motion to cancel. You ready?
Yes, thank you, Your Honor, I'm sorry.
Okay, that's fine. This is
I haven't learned how to clone myself yet.
not a problem. I know I'm
Thank
trying to, one of these days, I'm still working on most to save you guys.
Where am I? I'm in...
We've been asking,
Okay.
I've been gone, I've spoken to several judges. And I know there's a couple that are, well, we'll just leave it at that.
That's all. You don't need to say anything. No need to say anything else.
Your Honor, Scott Chansky standing in for Jordan Wagner on U.S. Bank versus Willie Waller. This is our motion to cancel the sale set for March 13th, Your Honor. It would be the third cancellation, Your Honor.
What's the basis for that?
Basis is, let me pull up my notes here. So we have a contract for conventional sale of property. The contract's for $115,000. Final
Is there a closing date set?
We can close on March 15th, Your Honor. There was, yes, the hiccup is there was a title issue because the father of the defendant died.
Okay.
The father is entitled. So we had to open summary administration to get the title to a point where it could be marketable.
Okay.
There's a hearing on that motion to get the summary administration on March 12th. Assuming that's granted, the sale transaction can close March 15th because all the other ducks are in a row, and then they can dismiss that, and then they can get their money, all their money, and dismiss the case probably by the end of the month.
All right, let me hear response.
Unfortunately, Your Honor, my client opposed to the motion.
Okay.
And that's the only instructions I have.
Okay, all right, I'm gonna go ahead and grant this one because I think you guys can get this done, but I'm gonna give you another sale date. I don't wanna extend it out open-ended, so let me go ahead and give you guys a 45-day sale date. That should be enough time for you to get the closing done, I would think.
Precisely what I was gonna ask your question.
All right, so 45 days, it's canceled, but it's reset with another 45-day sale date then.
Thank you.
All right, and then, for the 9:30, both sides here, we're just one side, right?
Yes, I don't believe.
I don't think anybody else is gonna appear, come on out, let me
Judge,
check.
did you happen to do a case this morning, Wilmington Savings versus Blondie Celestine?
No, I don't think so.
Okay.
You all right, orders of the
Yeah, just hand this bill. All right, let me do the 9:30. This is your...
Thank you, ma'am. 45 days?
Yeah, 45 days.
Thank you.
This is your MSJ in Petroleum Ventures versus...
Dixie Green
yeah,
Motors.
Yeah, and I read everything. Everything looks to be in order. You had everything. Your affidavits were ready, were appropriate. Your motion is appropriate. So I'm going to grant the MSJ for you.
Thank you, Your Honor. I have some copies here of proposed judgments.
Yeah.
Okay.
Just hand a copy to the bill. You guys have a question?
Yes,
You want to-
Yes, the language of the order states that the motion is granted just completely, but I just wanted to say that it was granted in part.
Yeah.
Because you reserved on the sanctions.
Yeah, let's put it granted part reserved. You're exactly right. Granted part reserved as the sanctions. You're exactly right.
Thank you.
All right, thank you guys. Have a great day. All right, Mark, let me know when we're ready on the next hearing. We have one more social session.